And so you can, I encourage the public, this is our general line there, that 510-238 number. Any questions that you have, issues that come up, please give us a contact or give us a call and speak with one of our housing counselors. We are available for questions or basically general advising Monday through Thursday, 9:30 a.m. to 4:30 p.m. We are closed on Fridays, but you can always send us an email at wrap@oaklandca.gov. Below is our actual building, our actual physical address, although right now we are still closed. And so in-person counseling has not resumed as of yet. And of course, please visit our website, www.oaklandca.gov/wrap. We have a ton of resources there. All of the material that I'll be covering with you all over the next, I'd say 45 minutes, an hour or so, you can find on our website. So let's get started. All right, so this is what I have on the agenda. We're going to talk about rent regulation and petitions, safe and habitable housing, evictions, security deposits, rental agreements and subleases, and landlord entry. All right, so the first thing we want to start with is, a breakdown of what the Oakland Rent Ordinance is. And these are the three pillars of residential rental law in Oakland. One is regulating residential rents, providing safe and habitable housing. And the other section is affording eviction protections. Basically, just cause will be required to terminate a tenancy. Chat box out the way. All right, so the Oakland Rent Adjustment Ordinance. These are the units that are covered, units that are built before January 1, 1983. And these are going to be 2 units or more on the same parcel. Remember that single family homes will not be covered under the rent ordinance. Those are exempt under state law. We can get to that a little bit more as we go along. The rent ordinance, as some of you, I think I've seen a comment in the chat, allows for an annual allowable rent increase, which is based on the Regional Consumer Price Index, which is the cost of goods and services over a determined sort of time for a particular metro area. As we all know, it was set to be 6.7% effective July 1st of 2022, but this actually may be limited to 3% if Councilperson Fife's amendment proposal actually does pass for during or at the second reading, which is June 7th. One thing to note is that only one increase is allowed in a 12-month period. And banking, which is currently prohibited, is basically any CPI-based rent increase that owner may delay for whatever reason, which they are then allowed to impose at a later date. So outside of the ordinance, the last bullet point points out that the moratorium prohibits rent increases above the CPI, which includes banking outside, or should I say prior to the moratorium, owners were allowed to pass along banked rent increases, and this could be for whatever reason. Maybe they just were aloof and didn't think about it, or they wanted to cut the tenant a break, or just thought it was too low to really be bothered with it. Those increases are banked, and they ordinarily will be able to pass those along at a later date. All right, let's talk about units that are exempt from rent control. These are single family homes with a tenancy start date after January 1, 1996. This is.
I had a question in the chat. Yeah, there was a question in the chat on the last topic about whether single family homes with an ADU qualify.
Where this next slide actually directly answers that question.
Perfect. Thank you.
So units exempt from rent control would include single family homes. And that is due to the state law known as the Costa-Hawkins Rental Act of 1996 that exempts certain properties from local rent control jurisdictions. Those would be your single family homes, your condominiums, your townhomes. Also government subsidized or controlled housing. Those are going to be exempt from rent control. Those would be units such as Section 8 tenants or Section 8 properties, because those rents are already regulated through that agency. And rental units built after January 1, 1983, those units are referred to as new construction. And so generally your ADUs are going to fall within that exemption. Also, units in a nonprofit, cooperative owned or operated, controlled by residents, those are going to be exempt from rent control, particularly because all of the owners, a majority of the owners live in those spaces. All right, so one thing to note about rent control, or at least rent control in Oakland, and generally across other jurisdictions, is that rent control is a petition-based program whereby both owners and tenants may petition the board for a rent adjustment, whether it be an increase or a decrease. But there's a petition process you follow to do that for most rent increases. In Oakland, increases above the CPI, an owner is going to need to file a petition for, with the exemption of baking. So these are the types of petitions that we offer that an owner or a tenant could file for a rent increase or a rent decrease. So we've got illegally high rent or failure to provide the RAP notice. These cover overcharges, multiple rent increases within a 12-month period. And this is not the exhaustive list. For those who don't know, the ordinance requires owners to provide what's called the RAP notice, the rent adjustment program notice, to tenants at the start of the tenancy in 3 languages. And then they must also provide RAP notice to the tenant with each rent increase in the tenant's preferred language. And so a tenant may file a petition for a rent decrease based on that failure to provide that RAP notice with their rent increase. A decrease in occupants allowed. This is generally going to be where a landlord reduces the number of tenants allowed below the base occupancy level. So in a situation where you have, say, 3 folks who move into a unit, they are all the original occupants, and let's say 1 or 2 of those tenants vacate, and the owner is, out maybe explicitly outright denying that the remaining tenant the right to replace, or just making that process unnecessarily cumbersome for that remaining tenant, she can file a petition for decreased occupants, a decrease in occupants, which would basically reduce the rent by perhaps maybe up to 2/3 if we're talking about 3 tenants starting as the original occupants. I'd say the most filed petition we see are going to be the legally high rent notice, but also the decrease in housing space or failure to comply with the implied habit of warrantability. So implied warranty of habitability. I want to apologize for the noise, so it might be a little loud over on my end. But so generally under state law, known as California Civil Code Section 1941.1, that section of the law sets out some affirmative characteristics that all owners of residential rental units within the state have to provide. And so those are things such as heat, running water, functioning electricity, plumbing, weather stripping, basic, sort of necessity things that a unit should include. When there are defects, as we refer to them, tenant may file a petition to have a rent reduced based on that defect or that the lack of that characteristic. Maybe the heat was out, hot water has stopped, The plumbing has been out for a certain time, things of that nature. She can also file a petition where there's a decrease in space or services. So maybe you moved in and there was a laundry facility on the property and the owner has taken that away. Perhaps parking was included with your lease and the owner has taken that away. These are the type of scenarios or grounds for which you could file a petition. The bottom right is a petition to determine initial rent after the unit has been vacated, right? This is where the landlord attempts to reset the rent because she or he feels the last original occupant no longer uses the unit as their primary residence, right? So to understand how this works, under Costa-Hawkins, an owner can reset the rent when they have a completely empty unit. In between tenancies, it's known as vacancy decontrol. This is the time that an owner is allowed under state law to reset the rent to market and put the unit back on the market. Sometimes, every now and again, we have tenants who don't use the unit as their primary place of residence, right? They may be using it as what's called a pied-à-terre, which is a vacation spot, or they may have permanently vacated and they've sort of subleased under a friend or a classmate, relative, or what have you, to sort of preserve the rent that they were enjoying at the time. An owner can petition the board to determine whether or not the tenant is actually using the unit as their primary place of residence or not. And if not, then the owner is allowed to reset the rent to market. The tenants who are residing in the unit have a right to stay, but they now are also going to be obligated to pay that new increased rent. Let me check the chat box really quick here to make sure I'm not any questions that may have come up. V asks to everyone, what if a landlord revokes shared use of outdoor space like the backyard? Does that qualify as a decrease in housing space? Generally, those are the types of scenarios that you would want to file a petition for. You may be entitled to a rent decrease, but that's definitely something that the counselors would advise you to file a petition and see whether or not you may be entitled to a reduction in rent because of that decrease in space. Common area does count. If it was offered to you, whether or not it was explicitly detailed in the lease, or if it was available to you and you were using it from the time of your tenancy with the owner's sort of knowledge, then you may be entitled to a rent reduction for that. Karina asks, is there a certain temperature that landlords are required to provide? That is a good question for code enforcement. I don't remember what it is offhand. I think it might be around 68 or 70 degrees, but proving that your unit, say, maybe lacks appropriate weather stripping or insulation can be difficult. I don't know exactly what the process is in Oakland. I would advise you to reach out to code enforcement and talk to a code enforcement officer about that and about maybe whether that might be the case. Because if they find that it is below, maybe you've been entitled to a rent reduction. Maybe that's something to file a petition for. Sarah Lockhart asks, what if the ADU was used as a residence prior to 1983, albeit not legally? Sarah, that means, so there's two ways folks think of legally when they think of rent control. They think legally as in code enforcement doesn't know about it. So it was illegally built. It was built without permit. And then the other, sort of legally or illegal is whether or not the owner is paying the RAP fee, the program fee, and abiding by the just cause and rent ordinance. And so I think what you are referring to is whether or not the unit was built with permits. Whether or not it's built with permits, it's more than likely going to come under rent control, and particularly because it was built prior to '83. So moving along, what to do if served with illegally high rent increase. The first thing you want to do is you want to file a petition within 90 days of service of the rent increase notice. And you may file it at any time if you did not receive the RAP notice at the start of your tenancy. But with a rent increase notice, you want to file it within 90 days. That's the sort of statute of limitations on that. You can find all of the petition forms on our website. After filing, you will receive a notice from our office in the mail with your hearing date, which are all virtual, by the way, right now. You will need to file with the rent board 14 days in advance of the hearing all the evidence that you want to present at your hearing. So what we advise folks to do, both owners and tenants, is, this isn't just you telling what is going on, you also want to support it with documentation. So that might be photos, that might be pictures, that might be emails or text messages, that might be a code enforcement tenant inspection report, right? That might be a PG&E bill. Everything that you can put forth that's going to show, that's going to substantiate the claim you're making, that's what you want to provide. But note too in red, if it is a petition for an illegally high rent increase, we do advise that you pay the rent increase, because what you're doing is asking for that, if you're successful, then the rent reduction you'll be awarded is sort of refunding that increase back to you, that illegally high increase amount back to you. All right, safe and habitable housing. Again, so housing must meet the standards under California Civil Code. This is the implied warrant of habitability. And these are the affirmative characteristics I mentioned earlier, right? Weatherproofing, plumbing and gas, sewage, right? Working electrical and wiring. Building and grounds free of debris, that's a good one. Free of garbage, rodents, and other pests. I'll speak on that one later on. Adequate garbage containers, floor stairways and railings in good working repair, right? If you don't have these things, or they were deteriorated over time during your tenancy, then you may have your rent lowered and or refunded through the rent adjustment program's petition process. All right, so what do you do when you have a habitability problem? First, you want to write the landlord to document the problems. We advise including photos. You want to ask for repairs. A lot of owners will use a portal to request, to submit your service requests. So you want to start there. Again, any documentation that you might have or you're allowed to upload, that's what you want to do. We offer free mediation services, so you can request mediation through our program. It is free, but it is also voluntary. So if you have a sort of tenuous relationship with your property owner, they may refuse to participate, but that's okay, because you can file a petition with us to have your rent reduced. Now, the second and third bullet point, these are your sort of fail-safes if, in fact, you have already written the landlord, you've documented the problems, you've asked for repairs, you've given the owner some time to cure, and for whatever reason, they have not, right? Generally, depending on the type of repair you're seeking, you want to allow anywhere from a week to 30 days. Something a bit more urgent, of course, is going to warrant, quicker action. If you've got a busted pipe, ordinarily an owner is going to be on top of that. If we're talking about weather stripping for a window, that may take them a little longer to get around to. Also keep in mind that some repairs may not be done by the owner or by his crew. He may need to contract out. So now he or she's got to sort of coordinate with other contractors who may or may not have availability right away. So keep those things in mind. I think that's another thing to, another reason why mediation sort of works. It's a less formal process. It's more of a conversation. You'll sit down with one of our trained mediators and attempt to hash out an agreement or resolve a dispute. And if that fails, again, the more formal process is filing a petition. For those who are experiencing a habitability problem, we always suggest to contact Oakland's Code Enforcement Division, and you want to request an inspection, and the number's listed right there. All right, so let's talk about the just cause for eviction ordinance. All right, so owners in the city of Oakland, for most units, are going to have to allege just cause to terminate a tenancy. All right, and these are, you have your at fault and your no faults. Your at faults are going to be, you know, your sort of common sense, sort of don't do that sort of thing. Non-payment of rent, don't do that. Substantially violating the lease, don't do that. Willfully substantial, you know, causing the substantial damage to the unit, we don't do that. Causing a nuisance, don't do that, right? Refuse to provide access to make required repairs, refusing to sign a new lease, and use of the unit for illegal purposes. Let me back up a bit to refusing to sign a new lease. It doesn't just mean a new lease, it means a substantially similar lease. So, and this is should also happen near the time of the expiration of your current lease. So if you've moved into a unit, for example, in January of 2020, your owner should be providing you with a new lease that is substantially similar to the current lease you signed. And you should be receiving that in the mail around, say, November, right? Gives you time to review it, gives you time to sort of decide whether or not you want to stay or get a move on. And then you decide to sign it, and it is going to be effective the day after your current lease expires, right? If that does not happen, let's say January 1 of 2021 rolls around and you haven't received a new lease. February rolls around and your owner says, no, January 1 rolls around, you've paid the rent, the owner has accepted it. February 1 rolls around and the owner says, hey, I got this new lease I want you to sign. Well, it's too late for them. Now you can refuse to sign a new lease. You are now a month-to-month tenant. The same terms of your previous lease apply, but they've sort of missed the window to provide you with a new year-long lease to sign. So that's something to point out because we get a lot of confusion over that, both from owners and from tenants. On the right side, we have no fault evictions. These are, as it sounds, these are evictions that are of no fault of your own. So, to the unit as a principal place of residence, this will be in your lease agreement. So this is a good reason to, read those agreements. This will also be something that, if the owner has plans on returning to the unit, this is something you're generally going to know before you even give the deposit. They're going to say, me and the wifey and I, we're going to go visit Europe for about 2-3 years. And so, we'll sign a year-long lease with you where we're new and then we'll return or something to that effect. So you'll have a heads up. That will allow him to terminate your tenancy. If you need to be relocated for necessary repairs, this would be in the case if the unit is just substantially damaged, say fire, flood, red tagged by the city, they may be allowed to terminate your tenancy for that. If the owner wants to perform an owner move-in, now this is a scenario where the owner did not state to you that they plan on returning back to the unit, and in fact, never actually, to your knowledge, lived in a unit at all. But this is the, in this scenario, they may be allowed to take possession of your unit, but they will also be required to pay you relocation assistance. And there's a separate schedule for that. Right now, I believe it's around $7,500 for a 1-bedroom, and $11,000 for a 2-bedroom, so on and so forth. And there's also stipulation for households who contain someone who is elderly, handicapped, has a minor child in the home. There's an extra $2,500 if any of those, if the household meets any of that, the additional criteria. Lastly is an Ellis Act eviction. These are evictions provided for under state law, known as the Ellis Act, that allows owners to leave the rental business. And that's exactly all they're going to be doing. What they do with the home after that time is generally up to them. But an Ellis Act eviction is, in a sense, not necessarily them wanting to move back into the unit. They are done with the rental business altogether for that particular property. So if you live in a, let's say a fourplex, and an owner wants to perform an owner move-in on a unit in that fourplex, she may be allowed to do so. Maybe she takes unit A. If she wants to perform an Ellis Act eviction, she's taking every unit on that property off of the market. All the tenants have to be relocated. They have to be provided with relocation assistance, so on and so forth. So it's a very cumbersome process for owners. Time consuming. There's a lot of approvals that they need to obtain. Again, they're going to be following the same relocation payment schedule. And, you know, but if they are done with the rental business, the law allows them to do so. If they decide to rent over the course of 10 years, there's sort of staged phases that they will have to go through, and some restrictions that apply and attach to the property over that 10 years. So for example, after 3 years, they say, I want to rent again. They actually have to offer the units back to the tenants who were displaced, right? So those sort of things happen over that time period. Lastly, I think this is something that if you leave here with, if you leave this tonight's presentation and you can't remember anything, please remember, sale of property is not just cause for eviction. Expiration of a lease agreement is not good cause for eviction. Foreclosure of a property is not just cause for eviction. I can't stress this enough. I might even type it in the chat. If you remember anything, just remember, seller, you can get a new owner. Only thing that should change is where to send the rent, who to call for repairs. If your lease expires, great, it expired. You're now a month-to-month tenant, congratulations, right? But none of these are good cause. And as you can see, this is pretty much the exhaustive list, and none of those items are on there. Let me take a look at the chat really quick. Drink some water. I've been talking a lot. Karina asked, does grounds free of debris include outdoor spaces? Yes, it includes the common area. 1941.1, the section that I covered in the previous slide, puts an obligation on owners to make sure the common area is free of debris, garbage, rodents, and the like. Chris asked, how long generally does Enforcement Division take to complete inspections after the request is made? I want to say about 3 to 4 weeks. It depends on their availability and how many site visits that they need to do and around the time that the request is made. Generally, they will schedule the inspection, perform the inspection, and then it will take maybe 2 to 4 weeks to receive a report of their findings, you know, what they may have cited the owner for. Let's see. Someone from EV asked, how about refusing to pay rent? Folks, I want to remind you, can everybody make sure you're on mute? Thank you much. So there's a question I was reading. Let's see. How about refusing to pay rent when if landlord violates lease or doesn't cure issues? There is a section of state law known as repair and deduct, which would allow a tenant to basically do just that. Make repairs and then deduct the cost of those repairs from the rent. There are other sections of the law that would allow you to withhold the rent. However, we don't ever advise tenants to do that because there are, so for example, under repair and deduct, there's a few elements that need to be met. You need to show that you requested the repairs, that, for example, code enforcement, that the owner was cited for those defects, still failed to repair, so on and so forth. So there are some, you know, even though the law affords that remedy to tenants, we advise them not to do that because you could be availing yourself to an eviction lawsuit for failure to pay the rent. And then, yeah, it's also, you know, you have, that's sort of what our petition process does for you. It looks at the facts, makes a determination of an amount of percentage that your rent should be reduced by. And generally, you know, owners want their rent. So when they find out that they're going to get less rent unless they fix something, they usually fix something. So, which I think sort of alleviates, I'd say reduces the tension between the tenant and the owner in terms of their relationship goes. Let's see, and I think
just one more question from Adama.
Yeah, Adama, give us a call. I posted the contact information. I don't know that there may be more, there's a lot more that we'd want to know before I could accurately advise you on that. And I don't want to turn this into a counseling session. I want to field questions that we can all sort of take away from. And we also may have some resources for you to help you unpack that. So give us a call or send us an email, please. What habitability, Sarah asks, what habitability issues tend to lead to red tags? Fire is a good one, right? Places destroyed by fire. You know, that's generally going to be red tag. Flooding, an earthquake damage, you know, sort of catastrophic stuff like that. Shella asked, where can I go to help fill out my tenant statement to the rent adjustment program? I'm not sure I understand what you mean by tenant statement, but I would say us. Give us a call. If there's something that you are, if you mean by petition, we do offer petition review. So our counselors will review your petition. We only look for, however, we look for completeness. We make sure you are dotting your I's, crossing your T's. We're making sure that you've included the proof of service. What we do not review for is sort of substance or relevance of the document, the supporting documentation that you want to add. So for that, we can refer you to a legal service provider because that is sort of legal advice and we don't provide that. All right. I called the rep 3 times and no one returned my calls. Oh, Adama, I'm really sorry about that. Try sending us an email then. Generally, we return calls within 24 to 48 hours. And if you have left a voicemail, we are pretty good at clearing the queue. So, please double check the number that you dialed. A lot of times, folks will mistakenly dial 3271. I get that a lot. But give us a call again or send us an email. And Sheila asked, yes, I need help for my case point. We will not provide you that. We do not provide legal analysis. That you would need an attorney for or sort of legal service provider, but give us a call and we can point you in the right direction for help. All right, moving along. All right, units exempt from just cause. So these are going to include units in any hospital, skilled nursing facility, health facility, rental units constructed after December 31st, 95 with a certificate of occupancy. These are going to be known as the newly constructed units. Units held in a trust for a developmentally disabled person. Again, this isn't the exhaustive list, but these are the sort of big points to pull out. Units where the owner resides as their primary place of residence and shares a kitchen or bath facilities with a tenant. This is one that we get more often than not. This is basically someone who is renting a room out of her home or out of her condo, right? That unit is going to be exempt from just cause. All right. This is a few bullet points on the emergency moratorium on rent increases. I think we're all aware of this, but I'll cover it a little bit. Applies to tenancies regulated under the Oakland Just Cause for Eviction Ordinance or the Oakland Rent Adjustment Ordinance. So these are currently the emergency moratorium applies to units that fall under either of the two ordinances from the previous slides I just covered. Most evictions are banned until the local emergency. So how that works is once council lifts the local emergency, then the emergency moratorium would lift 60 days thereafter. Exceptions to evictions during the emergency moratorium are if the tenant poses an imminent threat to health or safety of other occupants and the Ellis Act. So these are the two ways, the two exceptions the moratorium affords owners to evict during this time. A property owner cannot evict a tenant for failure to pay rent if the unpaid rent was due to a substantial loss of income or an increase in expenses resulting from COVID-19. Also, no late fees may be imposed for the unpaid rent that became due under the local emergency. If, again, the reasons the rent was late were because they were financially impacted by COVID. And again, the moratorium prohibits rent increases above the consumer price index, that's the CPI, and this includes banked increases. Let's keep it moving. So before we go into other tenant-related issues, let's see, Sarah has a question. If a unit was constructed after December 31st, 95 and does not have a C of O, does that mean just cause protections exist? Possibly. There's more to that, but possibly. That is something I would say, send us an email. If that is your scenario, send us an email, include your address, and one of the counselors can give you more accurate advising on whether or not your unit is exempt. If so, or even if not, we have a petition. One of the grounds on our tenant petition is where you believe the unit should be covered and is not. Refer a tenant and nonprofit that serves tenants. Yeah, Sarah, give us a call or send us an email and we can talk further. All right, let's go into security deposits. What is a security deposit? This is any payment, charged at the beginning of the tenancy as an advance payment of rent or to be used for recovering rent defaults, repair damages, or cleaning. This is governed under California Civil Code Section 1950.5. In plain terms, the security deposit is just that. It is the owner's security. They can use this to repair damages, basically cleaning and or repairs above ordinary wear and tear. And it's generally going to be everything collected after the first month's rent, because the first month's rent is the first month's rent. Security deposit limits. An owner may charge 2 months rent for an unfurnished housing unit and 3 months for an unfurnished housing unit. Or excuse me, for a furnished housing unit. I think I said that wrong. 2 months for unfurnished, 3 months for furnished. All right. This is the burning question everyone wants to know. Reasons landlord can deduct from your security deposit include to cover a default in rent, damage caused by the tenant exclusive of ordinary wear and tear, necessary cleaning, to replace the landlord's property. Let me speak on a few of these. I think cover a default in rent is sort of self-explanatory. Damage caused by the tenant exclusive of ordinary wear and tear. The question there is, what is ordinary wear and tear? I'll give you a couple of examples, and you can do some Google searches to sort of get a better idea of, sort of what courts have determined was ordinary wear and tear or exclusive of that. One example is paint. Paint, as we know, fades, paint chips. Paint generally has a life of, I believe it's 10 years, right? That's ordinary wear and tear, right? But the crayon mosaic that Junior drew on his bedroom wall, that's going to be exclusive of ordinary wear and tear. Or that one wall that's behind the couch and everyone flops on, and it sort of creates that groove in the wall from everyone flopping on it, that's going to be exclusive of ordinary wear and tear. That's going to be excessive, right? Carpet, I believe, has a life expectancy of 15 years, 20 years, somewhere like that. And we know that carpet peels at the corners, at the wall. Carpet wears, right? And can even create a trip hazard. That's ordinary wear and tear, right? But pet stains, wine, burns, right? That's all exclusive, right? That's above ordinary wear and tear. The owner can deduct to repair that. Necessary cleaning is just how it sounds. One thing that that's not on here that is actually mentioned in the law is they basically can use your deposit, can deduct from your deposit to return the unit that it was in when they rented it to you, right? So the same level of cleaning that the unit was in when you took possession of it is what the owner is entitled to inspect, entitled to once the unit is returned back to them. So one tip that I advise tenants to do, and a lot of property owners and property management companies do, is they will walk through when they're showing you a unit or you've already put down the deposit. They do that sort of initial walkthrough. They'll have the checklist, right? Which is super helpful. It's not just performative. They probably they file that list somewhere and they pull it out when it's time for you to vacate, right? Similarly, what you want to do is you want to create your own list. You want to walk through and take pictures of everything, whether it's fixed, broken or not. You want to take pictures of everything. This is what the unit looked like when I took possession. This may help you if there's a dispute at the time that you are moving out. Next slide. Okay, so security deposit return. the landlord has 21 days from the time the tenant fully vacates the unit to return the deposit. That clock is generally going to start at the time that you have given the key, right? Given possession back to the owner. They'll have 21 days to return your deposit or return a portion of it with, after they've made their deductions. They will also provide you with an itemized list of what those deductions were for if they did make some. If those deductions exceed $125, then the owner now has to provide you with receipts, invoices, or even estimates to have, to make repairs or maybe whatever cleaning that they deemed was necessary. They have to provide you with that documentation along with that itemized list. Your remedies, let's say after that 21 days has transpired or has passed, and you are either have not heard from your owner, former owner, or you want to dispute the amount withheld, you can file a suit in small claims court against them. And 1950.5 section of the Civil Code allows you to ask for twice the amount withheld, the ceiling of which is 3 times the deposit given, right? For bad faith retention. What you can also do is, again, request mediation with us. If the owner is, maybe you're having some back and forth over what the deposit, what the deductions were for. If they are just not responding to you at all, then it's probably not going to, volunteer or participate in mediation. One thing you want to do, or that we advise folks to do, is after that 21 days, if either you have not heard back from your owner or you want to dispute the charges, is to send them a demand letter. Sir, madam, I vacated on this day, and I'm demanding the full return of my deposit back. Also, what's not, I believe it's on the next slide. Before you move out, what you want to do is provide the owner with proper notice, and proper notice is at least 30 days. So you want to send the owner a notice of your intent to permanently vacate 30 days prior to you vacating. And in that, you want to also offer the owner a few dates for you and her to get together and perform what's called or is known as a walkthrough inspection, an initial walkthrough inspection. This should happen 2 weeks prior to your last day in the unit. And this is actually in the law, should happen 2 weeks prior. The purpose of this walkthrough inspection is for yourself and the owner to get together, and for the owner, you guys compare notes. They're going to pull out that checklist that she checked off when you moved in. You're going to compare what documentation or whatever you might have had when you moved in. You'll most likely you're going to also have a copy of that checklist, because a lot of owners are smart enough to sort of have both parties sign, okay, yeah, everything was okay. You're going to sign up this checklist. They're going to sign up the checklist. You guys are going to compare notes, and they at that time are giving you an opportunity to identify, or the owner's going to identify any cleaning or repairs necessary that you can perform within that remaining 2 weeks to prevent them from deducting from your deposit, right? One thing I forgot to mention from the previous slide is it said personal property. The owner can deduct for personal property. This can be keys, right? Or your key card, right? Your lease is probably says something like, replacement of a key card to get into the unit is $25, right? Things of that nature. Lights, sconces in your apartment, that's all personal property. If that needs to be replaced, you'll more than likely will be on the hook for it, and they can deduct it from your deposit. I'm going to stop for a bit and look into questions. Karina asks, is a pet deposit refundable or does it vary? I think it's generally, so I know Oakland's ordinance does not have a section for pet deposits really, but the general rule is this. Pet deposits are allowed. I think it's, you know, pretty self-explanatory what the deposit would be used for. All deposits are refundable, right? So if you gave an additional, well, let me back over for a sec. So the previous slide, I mentioned that an owner can charge 2 times the rent for a deposit, right? Two times the monthly rent. So let's assume that the rent on a unit is $1,000. That means that they can charge you $2,000, right? And that's it. If the owner allows you to have a pet and they want to charge you a pet deposit, generally that's it. They're at the limit. They can't go above that 2,000. They've already collected their ceiling from you, right? That doesn't mean that you don't have to, that you can't. If you want to give them, okay. That could, maybe pose some issues for you later on, but generally that's going to be their issue. Is that they've already collected the full amount that they can collect from you. They can't collect any more, right? So in that instance, they are going to be risking having to perform any repairs or cleaning with less deposit. If they charge you $1,500, though, now they have $500 of cap space that they can now demand a pet deposit from you for, and say, charge you $300 at the time that you moved in, right? Or at the time that you adopted your pet. Is there a certain amount of years after which a landlord can no longer deduct from the deposit? Generally, I believe so they should be making the deductions within the 21 days, right? That we just discussed. Anything outside of that sounds like it might be a civil claim against the tenant. But I'm going to say the law says they have 21 days to make those deductions. And that was V that asked that question. She asked, is there a certain amount of years after which a landlord can no longer deduct? For example, if a tenant has lived in a unit for 15 years, are they still subject to the deduction? The deductions happen after the deductions happen after the tenant vacates, not during. Tasha asks, I hope I'm pronouncing your name right. I've been told you cannot be charged for carpet cleaning or repair upon leaving a unit after 3 to 5 years. I don't know about that. I don't know that that's accurate. Carpet needs to be cleaned. Carpet can be damaged. I think it'll come down to the condition of the unit, that the condition the unit was in, that the carpet was in when you took possession of the unit versus the condition of the carpet when you vacated. So I don't know about that. If you have a particular scenario or situation that you want to talk about, give us a call. Can EB Prec, that's what I'm going to call you. No, and a landlord, he asked, the EB Prec asked, can a landlord deduct from a security deposit before you vacate? No. The deductions happen between 21 days between the time you have turned over possession of the unit. You're welcome, Karina. Let's see. Specifically, and Tasha clarified, specifically carpet normal wear and tear. Generally, if it's normal wear and tear, no, they cannot deduct for that. And whether or not the repairs or cleaning complained of rises to the level of sort of beyond ordinary wear and tear would be an issue for a court to decide. So moving right along. V asks, is interest owed on security deposits? Not in Oakland. Subtenants and sublessees. Let's see how are we doing on time. 6:30. Cool. Subtenants and sublessees. So this is in scenario that we see often with group living arrangements, and I'll tell you how they get created in a sec. So, but these are the general rules. Subtenants must abide by their original lease. They're going to be paying the rent to the master tenant. Generally, an owner is not going to be accepting rent or recognizing repair requests from a subtenant. Master tenant can evict, but will also need just cause. Master tenants sort of step into the shoes of the owner. A subtenant should be charged a rent that's proportional to the space and services that they are occupying. Subtenants may also file a petition against the master tenant if they believe they are being overcharged, and that is a new section of the ordinance, 13649. Down at the bottom, please be advised that when a master tenant or last original tenant vacates, the remaining roommates are subject to what we call a Costa-Hawkins vacancy rent increase. And this is more than likely going to be a market rate rent increase. So let me talk you all through this. 3 roommates move in, A, B, and C. They all are original tenants. They are all named on the lease. C vacates, and D replaces her. So now we have A, B, and D in the unit. D is a subtenant, and D will be a subtenant under either A or B, or A and B, right? But they will serve as these master tenants, right? A and B will be charging the rent proportional to the space and services that she uses and occupies. And she can file a petition if she thinks otherwise. Let's say that D is in a unit and B vacates, gets replaced with E. And then at some point later, A vacates, right? Now this is what we call a Costa-Hawkins event. All of the original tenants have permanently vacated the unit. The owner can now treat this moment in time as if she has a completely empty unit, whereby she can set a new initial rent, and she can offer a new lease to those now 3 subtenants who are remaining in the unit. Note that the subtenants have a right to be there, right? But now the owner has a right to set a new rent. And if the subtenants cannot agree or don't want to agree to that new rent level, they'll have to get a move on. In a gist, that's how these Costa-Hawkins events work, and how subtenant and subleasing works. Excuse me. All right, breaking a lease. This is a section of the law governed under Civil Code Section 1951.2. These are the takeaways. You can always break your lease. However, there may be costs for breaking your lease early, right? So you want to read the agreement. There may be some sort of penalty in there for early termination. Remember, we just talked about 1950.5, where the owner may be allowed to deduct from your security deposit for unpaid rent, right? So they may be able to withhold your deposit because you're breaking early, right? But what you want to do in the event that at the same time, life happens, we need to get a move on, you're allowed to break the lease. You're not a prisoner. When in fact you find yourself in that situation, you want to provide the owner with at least 30 days written notice. I advise tenants, as much prior written notice as you can. As soon as you find out you need to be getting a move on, you might want to start talking to the owner, particularly if you've got a lot of time left on your lease, right? However, under California Civil Code Section 1951.2, owners have a duty to mitigate their damages by attempting to re-rent the premises through reasonable and good faith. So what this means is that, let's go back to our scenario of moving into a new unit January 1, 2020. And somebody here just got accepted into the school of their dreams, and semester starts in September, and they've got to get a move on, which means they've got to break their lease, which means we've got September, October, November, December, 5 months left on that lease. Once you've given your owner the 30-day notice, the owner has, this section of the law is putting an obligation on the owner to put their best foot forward and mitigate their damages by trying to find replacement tenants. The law does not allow an owner to just sit on their hands and say, well, we had a contract and you breached it, so I'm just going to, deduct, pretty much usurp your entire security deposit and possibly pursue you in small claims court, right? Because you basically broke this contract we have. The owner will have to show that she did everything in her power to re-rent that unit before she could, escalate things to that point. And again, so let's move to the next point. The property owner may have the right to all or a portion of your security deposit. Again, that's if they've shown that, hey, I've tried everything possible and I could not rent this place, or my tenant skipped out on me at a really bad time, so on and so forth. And again, any challenge to the deduction from the deposit can be made in small claims court. Moving along. All right. I think this is the last topic, subject, but this is a good one. We get a lot of calls on this, lots of emails too. Let me just say, one thing I've noticed in my career is that some owners just have a hard time differentiating between their rights as owners and the property rights of the tenant. They just have a hard time recognizing that there's a difference between the two. And they, for whatever reason or another, sometimes they just simply don't know that there's a rule that sort of regulates how and when they can just pull up to the unit, and for what reason. Some of them are good-hearted and they do it by mistake. Others are just, they just have a different perspective and they feel like, well, this is my property, I can do what I want. And so sections of the civil code, are in place to protect the tenants in those scenarios, and just sort of lay out the groundwork for everyone moving forward. I would advise you all to get comfortable with this section of the California Civil Code, Section 1954. This governs when an owner may enter your unit, and it's enter your unit. That's not necessarily entering the common grounds, but entering your actual unit, right? Because remember, a few slides back, we talked about the warrant of habitability, which puts an obligation on the owner to keep the common areas, free of debris, garbage, right? So she generally won't need to notice you when they are going to, for example, send the landscapers over, right? Or just check on the condition of the recycling bins, or things of that nature. But if they want to enter your unit, there's a process. So it should be, they are allowed to enter your unit only during regular business hours. They must provide the tenant with 24 hours written notice, and written notice does mean hard copy. A lot of us in this day and age communicate with our owners, via text message or email. But the law recognizes hard copy. That's not to say that you can't push back. If you're perfectly within your rights to say, hey, that's fine. If the owner texts you and says, hey, I need to come over for this, that, or reason, the following day, 24 hours notice, and you're okay with that, fine. But his obligation is to provide you with written notice. We advise owners who communicate with their tenants like that to still provide written notice, even if they generally communicate through text. The landlord has a right to enter your unit to make necessary or agreed upon repairs. So again, you've made that service request. The bathroom faucet is leaking. He has a right, she has a right to send a crew over to make that necessary or that agreed upon repair, right? Or agreed upon meaning that you asked for something to be installed, maybe some blinds, who knows. But that agreed upon repair, they're allowed to enter. They are allowed to show the unit to a prospective renter or buyer, right? So this is in the event that, let's say you're breaking the lease. You've given them 30 days, given them notice that 30 days from now, you are not going to receive rent from me, right? And remember that other section of the law that puts an obligation on the owner to start to put their best foot forward and make good faith efforts to re-rent that unit. Well, they may need to show your unit to a prospective renter, even while you're occupying the unit, right? And of course, in the case of an emergency, or if they believe the unit has been abandoned or there's a court order, there's no notice required for that. And I think that's pretty self-explanatory. One thing to point out, and one thing that folks don't really pick up, because it's not written in the law, but the tenant's presence is not required, right? Because remember, they can only enter during normal business hours or regular business hours. And so before everyone was working from home, you might be in the office at 1 o'clock on a Wednesday when the owner needs to bring the repair guy by to fix that leaking bathroom faucet. So your presence is not required, but the 24-hour notice, part of the function is to give you an opportunity to, hide your valuables, make sure the pet is in her crate, things of that nature. So let me take a look at some questions really quick. Chris asks, is there a way to hold an owner more accountable for the fourth point on mitigate statement? Like what's strong way for tenants to document, engage, and the landlord being passive? One thing that we do, Chris, that's a good question. That's a really good question. You actually reminded me of something, so thank you. When you are, if you have to break your lease, along with that 30-day notice, or the notice as soon as you can, what we also, what I used to advise tenants in Berkeley is do a search yourself. Partner with the owner, right? I'm leaving. I know I'm breaking my lease 5 months earlier. Let me assist you in finding replacement tenants, right? They may say yay or nay. That's fine. But what we have also advised tenants to do is to list the unit yourself, right? To show interest in the unit, right? You may use, apartments.com. You may put it on a listserv at the school that you attend or whatever. You want to be able to show that there's interest in your unit, which may help you foreclose on the owner's argument that she couldn't find interest in re-renting the unit. So you will have to get creative. I'm sure some legal service providers or attorneys who deal with this stuff more closely than we do would give you some other tips and tricks, but that's generally how you want to be thinking when you are in a situation where you need to break your lease, right? How do I protect myself to make sure that my deposit isn't deducted from? Let me scroll down here. Chris also asked about entering rooms and internal unit without consent or 24-hour notice is illegal, would that complaint be directed to RAP? Great question again, Chris. You are our overachiever tonight. Chris asks whether entering rooms internally, you know, like bedrooms within a unit, I'm assuming, without consent or 24-hour notice is illegal. Kind of depends. You know, if the rooms are being rented individually under separate leases, then they will be considered units. And so, yes, notice will be required. To enter the unit, you know, generally notice is going to be required. 24-hour notice is going to be required. And doing so without any of the emergency exceptions being present is probably going to be it's going to be a violation of the rule. One thing that I don't have on here is what's known as the Tenant Protection Ordinance. That's also under Oakland law. This section of Oakland's municipal code protects against unwarranted evictions and harassment. And one such form of harassment is abuse of California Civil Code Section 1954, right? And that section of the law affords remedy through the civil courts for tenants who feel they've been aggrieved, right? So to answer your question, Chris, this would not be something that this is not a complaint that we would adjudicate. We don't have a petition for landlord entry, right? But our counselors could certainly, offer you guidance on that, and then ultimately either refer you to a legal resource provider, or perhaps you might end up in small claims court yourself. Let me scroll down here. Tasha asks, is the current owner obligated to inform tenants that the property is for sale? I don't know of a rule that obligates owners to inform tenants that the property is for sale. I don't know that there is one. I think it's good business practice for them to do so, but I don't know that I don't know, and I feel like I would know that the section of the civil code that obligates them to do that. But I apologize. Remember that under 1954, they can show the unit to prospective renters or buyers. So at some point, you will know that the property is going to be up for sale because they're going to be wanting to show the entire property or perhaps one of the units on the property. So ultimately, you would find out, and if you did, it would be by way of this rule here of landlord entry. But I don't know that there's an actual rule, separate rule that obligates them to inform the tenants. I'm glad Miriam found the information helpful. And Chris asked, Chrissy, I think you would have to coordinate with B in terms of the video. Let me get back to the slide. So let's continue. So we got next. All right. These are just some tips and tricks, things that we suggest. Documentation, get everything in writing. Those verbal agreements that you discussed with the owner at the beginning of your tenancy, those are going to be difficult to prove. So if not impossible, it's just going to come down to hearsay if it's a petition, or maybe you're in court or something like that. So one thing that we advise folks to do is, if you have one of those sort of conversations, those verbal conversations, follow it up with an email. Dear sir or madam, thank you for speaking with me. We talked about this, that, and the other. These are my action items. These are your action items. If I missed anything, please respond or something like that. That's proper documentation is going to include, the agreements and promises, right? So maybe he promised you the 4th parking space, and you really want that 4th parking space. That might be something you send an email about. All significant discussions. Him allowing you to, adopt a pet when the lease agreement says no pets, right? Roommate agreements, addendas, and subleases, make sure you get all of that stuff in writing, right? So back to our scenario of A, B, and C vacated and they brought in D. A and B would be well served to create a sublease agreement with D, right? And may be able to evict for violations of what's in that sublease. Also consider renter's insurance. You know, if you can afford it, it's fairly cheap and it's very worth it. Things happen that are outside of anyone's control. And so it's a good fail safe. Read your lease agreement because some will require you to carry renter's insurance, right? And if something happens and you don't have it, that could be, you know, you could you know, be in a bad situation. Let's move along here. Again, here's our website. These are all of the things that you'd find at www.oaklandca.gov/WRAP. And one thing that I would advise you all to do is to download the guide. I'm going to put this in the chat. Oakland's Guide to Rental Housing Law. Literally put that in the search and download that document and read through it. And join our email list as well. We have a listserv. We send out email updates that ask you for, you know, name, first name, last name, email address, phone number, address, you know, whether you're a tenant, property owner, you know, property manager, what have you. All of the things such as like our workshops and seminars, we send out an email blast for that. The annual allowable rent increase percentage, we send out an email blast for that. Basically all of those, you know, sort of big updates, we send out an email blast to keep folks informed. So I think it's a good thing. And again, our contact info. We are nearly at 7 o'clock. Here, let's see. Okay, that doesn't look like that was a question. All right.
Thank you so much.
We've got a few folks who hung out, who stayed the course. I will hang out for a few minutes and take some questions if anyone has them.
Thank you so much, Marvin. Thank y'all for coming through. I hope y'all learned information that felt supportive to you. I have a couple of follow-up questions really quickly. When a renter uses the petition and does get a rent reduction, is that a permanent reduction or is it for a set amount of time? Or are there cases where it can be one or the other?
It's cases where they could be one or the other. So, for example, if you have, you've been paying an illegal rent increase of $50 for 4 months, right? Then you've overpaid $200, right? So the hearing officer is most likely going to just reduce your rent for 4 months by that $50 until you're paid off, right? But another example would be when an owner decides to change the use of some space that you were using, right? So remember my earlier scenario of the, you know, that there was a laundry facility on the unit that the owner decided to pull out, right? So that's going to be basically a permanent, if awarded, it's more than likely going to be a permanent reduction for the length of your tenancy.
Super good to know. So I'm gonna go ahead and stop the recording unless other folks have housing related questions, but I did want to name that the question about noticing to tenants about selling properties is something that is included in an upcoming policy called the Tenants Opportunity to Purchase Act that Chris mentioned in the chat. That should be announced next year. But definitely inviting folks to get involved with us as we do some organizing and base building to get that passed when it does get announced and introduced. And will we be able to send these slides out to folks after this?
I don't know. I'm gonna have to get back to you on that. This is basically City of Oakland property. So I'm not sure that we can distribute these. This is basically a presentation. We do offer these slides in PDF form to those who attend our workshops. So the folks who register for our workshops, you know, they sign up with their email address, and shortly afterwards we send them a copy, not the actual slides, but of the PDF. So I'm tempted to say no, I don't think I can provide these in this form.
Okay, maybe we can talk offline about whether we could get that PDF instead, but I do see that Donna has her hand raised.
Hi. I just have a follow-up question about the process for the Ellis Act for filing for it.
Mhm.
So the city of Oakland sent me a letter that says that my landlord filed for the Ellis Act and that I have 4 months to move.